organization. Pleasure for me to be among you. As you've introduced, my name is Michele Dubini, and I am leading the training team of the European IP Help Desk. I am a lawyer by training. I am specialized in intellectual property law, and I've been working, however, outside the litigation for my whole career, especially in Horizon projects, starting 12 years ago with FP7, then Horizon 2020, now Horizon Europe, and hopefully in the next framework also with FP10. Let's see basically what's going to happen. I joined the European IP Help Desk when I started working for a former company, and I'm still, let's say, helping small and medium enterprises and researchers. The challenge that is represented by the usage of intellectual property and intellectual property rights within Horizon and for exploitation strategies. Today, we will be talking about protection inserted into the general obligations that are mandatory by the grant agreement and that are also included in the consortium agreement. And I'll try to share with you some hints and tips that I have basically also that I have gathered throughout these years when I've been working and having a lot of examples basically from companies and also from consortia. I would start by a short introduction, really one single slide on the European IP Help Desk, which is the initiative that allows us today to be together. And the IP Help Desk is founded by the European Commission. And the main objective is to help small and medium enterprises and researchers and also potential or beneficiaries of EU-funded projects understanding and using intellectual property rights. Everything we do is free of charge, and also it's a first line support, which means we're not going to substitute the work of patent and trademark attorneys. So we don't file for patents, documents, or we don't draft IP agreements. However, we can provide knowledge regarding how to do those activities. And the way we do that is showed here on the right-hand side of this screen. As you can see, there's a website, ec.europa.eu/IP-helpdesk, and through the website you can have access to the different activities that are here in the clouds. So trainings on the individual basis, for example, also like today, there are publications available which can be downloaded. There is an ambassador scheme across the European Union and also in Latvia and other Baltic countries, but pretty much in every country of the European Union and even beyond. If you check out our website, you're going to be able to see where they're based. And also there are events organized by the European Commission for Awareness Raising, and we are very often present there. Most interestingly, though, there is a helpline, which means that you can address your question to the helpline, and they are going to be answering within 3 working days. For example, if you're unsure about some protection methods that could be applicable, they can explain you how they work, or also regarding consortium agreements, if you receive one and don't know exactly what's written in there because there are changes from the normal DESCA model, they can explain to you what's the intellectual property part of the contract about. Having said that, I'm going to jump directly to our presentation, our contact, which you will receive as soon as the presentation is over, because I'm going to send it to Maris and it's going to be a PDF sent to all of you. So yeah, don't worry about that. If you'd like to ask a question, I'm very happy actually to interrupt also my presentation. I think you can unmute yourself because I was talking to somebody at the beginning. So then you can actually stop me and address me with a question, or you can keep your questions for the end of the presentation, and I'm going to do my best to answer to these questions. Today we're going to be starting by the very basics, because I think we need a little bit of context to the protection activities, and the basics are the main agreements and the specific vocabulary that we have in the Horizon, let's say, framework, because it's like formally English, but finally, when those words are into a specific field like the proposal phase or also the project life cycle, they acquire a slight peculiar meaning that would be considered in some cases a little odd, to say the least, by a mother tongue English speaker that is outside, let's say, the background of Horizon. After this, I will focus on the rules, as I said, so the obligation that proceed from the grant agreement that are connected to these agreements and vocabulary. And among them, there is the general obligation to protect. In there, I try to make you a sort of panoramic about the role of protection and how to follow the general obligation to protect. But also connected to that, there's often a question of how to get along, let's say, between the general obligation to protect and disseminate. So also with the open access principle and how to deal with it, basically. And then finally, the general obligation to exploit, because everything we do in terms of protection within the project is then finalized to the usage of the project results. A easier, let's say, way to use them is granted through the monopoly given by the different intellectual property rights. So regarding the agreements, very briefly, because I'm pretty much sure that you're all aware of them, that's the general situation that we normally find in a standard Horizon Europe agreement, which is the relationship between the European Commission and the coordinator that signs the grant agreement. Then the other beneficiaries access through the accession form to this grant framework agreement of the project, which is the grant agreement. And we also have an additional agreement, which is the consortium agreement that is used in order to regulate the life cycle of the project and the relationship between the beneficiaries and the coordinator among themselves. And so this way, through the consortium agreement, we basically constitute a consortium, which is the entity without, let's say, legal personality that has the duty to carry out the project activities as they have been written into the description of action. Now, the grant agreement is basically the constitution of the project, and no rule that we write down in the consortium agreement or other agreements connected to the project may in any way contradict what's written into the constitution of the project, so in the grant agreement. But as we will see, in many cases, those rules written in the consortium agreement can be very useful because they go deeper into the description of the framework of the rules laid down by the grant agreement. Because just like a constitution, the grant agreement is very general in its disposition. And so if we only had the grant agreement, it would be quite hard for us to understand what is it that we may or may not do because of the rules that are so basic and general. And we will see an example of this through the rule regarding ownership of project results, which is a very important matter, and very often it creates confusion within the project beneficiaries group. But before diving into the general obligations, we need to be aware of what I was telling you, the specific continental English, I would say, terminology that are used into the agreements that I have just mentioned. And those terminologies are, for example, background results, exploitation, which is a very ill-chosen word to say what the Commission wants to say, dissemination activities, and also access rights. I'd like to, let's say, recap the meaning of those words because very often they are misunderstood. So the background is what we bring into the project. Background information is the backbone, let's say, of the project activities, and basically everything we do can be based on these initial information. Then it then gets transformed throughout the project activity and the project lifecycle into project results. Background is normally found in a specific part of the consortium agreement, which is the attachment 1. The problem is that very often the background is not properly described, and I see many consortium agreement that simply leave the background part open or empty. And this is potentially a problem because on one hand, it does not show what are the information that could be necessary or needed by the project partners in order to carry out their activities. And in another way, partners do not show what their contribution has been in terms of feeded information to the project activities. And that's often because of lack of time or also lack of experience of the project partners that decide with quite uh, sensible decision, say from my point of view, to leave the background empty. So the suggestion here would be always to check the attachment 1 of your consortium agreement of your project and see all the necessary information that you're going to be needing from another partner is there, and to ensure that all necessary information that other partners might need from you are also there written down on your table of the attachment. The background is then, as I said, going to be transformed in a way, evolves through the project lifecycle, and it becomes the project results. Project results are the creative output of the project. And if we take the definition of intellectual property, we understand that they are actually in the project language a synonym, in the sense that intellectual property is described by the output of the individual activity of and creative activity of the human brain. And at the same time, results are the output of the creativity of and also the research activities of the principal investigators. So when we say IP or when we say results, we're basically saying the same thing under a intellectual property point of view. You need to be careful though, and I think I have a slide for that before, because I often see that people confuse the terms IP and IPR, which is a mistake, because in that case, we cannot use them as synonym because they're not. Because if the intellectual property is the creative output of the human brain, intellectual property rights are juridical constructions that are used to, first of all, give a embodiment to a something that does not have a tangible nature. Intellectual property is intangible per definition. And at the same time, to identify a potential owner or author of the output that has been generated. And so, first mistake, be careful also in the proposal. It's not really like a matter of life and death, but still it's a mistake that could be easily avoided as long as we know what IP and IPR means. Then we have the access rights. This is a particular rule that I will show later on, but we need to understand that by joining the project, we implicitly agree to share the background information, but also the results that we're going to be generated. In any case, those results are going to be needed for project activities or also for exploitation activities. And then there's the word exploitation, which brings us to, let's say, living example of what I was saying before, that what we're speaking is actually not necessarily always English, but it's kind of evolution, or in some cases involution as well, because exploitation in the English language can actually mean a negative connotation of the use of something. So if you can exploit the rainforest, you can exploit human beings, and so on. In my personal opinion, speaking also German, my idea is that in the moment in which the word exploitation was chosen, there was a very strong Saxon inflection in the choice that comes from the word Auswertung, which means valorization. And it's and that's also the reason why it looks like in Horizon in FP10 the word exploitation is going to be substituted by the word valorization, which is much more fitting to what we want to mean through the project activities. In fact, exploitation in Horizon Europe means usage, utilization that can be direct or indirect of the results in the research activities. And please pay attention, it does not mean monetization of those results or commercialization necessarily. We need to be aware of what are the characteristics of our projects, and depending on these characteristics, we need to find the exploitation activities that are mostly fitting to what we want to do. And so not necessarily commercialize if something is not really fit for commercialization or still with a technology readiness level that is far away from the market. Then there's the word dissemination, incredibly often confused with the concept of communication. And that's quite a mistake, actually, if you're writing down a proposal and you confuse the word dissemination with the word communication. I think I have a slides coming up next when we talk about the general obligation to disseminate, but by a general rule, you need to remember that you talk about dissemination every time that your object of the sentence is a project result, because you want, let's say, to publicize your results so that a third party that potentially is interested in them is going to be able to use them. And so you foster exploitation by allowing potentially interested third parties to be aware of the existence of the project results, which is not what communication does. Communication within the project lifecycle is just a outpulsing of information, so outbursts of information without a specific target that is there in order to communicate information connected to the project. So you do communication activities, for example, when you set up your website at the beginning of the project, when you make the fact sheets regarding the principal investigators or the institutions that are involved in the project activities, or you also make communication activities when you communicate the aims, the goals of the project and its budgets and its timeline and so on and so forth. Those communication activities, those information really have not a direct connection with the project results, and so they cannot be considered as a communication activities. The key to read the difference between the words dissemination and communication is to find the object of the sentence. If that sentence object is a project results, then we're very likely to have dissemination as long as we find potential targets. If it's not, then we are in the realm of communication. Please also take this into consideration, because if we were English speakers, like discussing into a bar or a pub, for example, we could use the word dissemination or communication, let's say, as synonyms, which, however, in the project proposals background, they're not. And then after this quite long premise, I would say, we can jump to the main rules that I was talking about, and that also involve the protection of intellectual property rights. But I'll start with the general obligation, with the rules on ownership and the ownership of project results. Here, we see an example of what I was trying to explain to you before regarding the concept of constitution and grant agreement. So that the grant agreement has very general rules that by themselves very hardly are possible to apply without doubts. And the grant agreement simply says that results of a project belong to the participants generating them. It's a very easy sentence to understand, but very, very hard to apply if you consider that in project life cycles, we can have 20, 25, 30, 40, 50 different partners potentially, and that there is no definition of what it means to generate project results. So what it means to contribute to the generation. For example, I had cases in which companies that were simply organizing the project, like determining project meetings or also reminding deliverables and so on, would be claiming pieces of ownership of the project results because they themselves considered the work that they had done necessary for the generation of project results, which in a way could be also true in the sense that without those meetings, probably the partners wouldn't have had the chance to organize themselves and therefore come up with a project results. Nevertheless, the question shouldn't be really about the organization, but about the scientific contribution that has been done in order to generate project results. And so you can contribute to the generation of the results in a scientific way if you have the preparation for that, the activities in the work package, person per month that have been dedicated to that, the machinery that are connected to this generation, the background, as I was saying before. So there are, let's say, multiple objective elements that are never mentioned in the grant agreement or also in the consortium agreement that in the practice may really determine whether a contribution has been shall be deemed necessary for the generation of the project life cycle results or not. And so we can, however, add those say objective elements or measures to identify those objective elements into the consortium agreement, because the consortium agreement is an open document that every project can modify at their please in order to ensure that the exploitation activities are as smooth as possible. So the ownership of results is an example of how the consortium agreement can come into play and be a method or a tool in order to make the grant agreement rules more precise and more adapt to the project activities, taking them down from the generality in which they have been written down, standardized by the European Commission for the grant agreement. And so a practical situation that we find into different projects is a state of joint ownership in which we try to identify objectively the contribution for the generation of a project life cycle, and we actually realize that there is more than one partner that is the owner of the different project results generated. And that's, if you think about it, is not quite, or should be considered not as an uncommon situation, because the very goal of the project is to put different partners into collaboration so that they can generate project results. And so the fact that they contribute to the generation with scientific outputs is quite common. And so in this specific case, joint ownership can arise, and we need additional agreement to the consortium agreement in order to regulate this state of joint ownership and see what can be done by the different parties and at which point. Why do we need an additional agreement? Because in the moment in which we draft the consortium agreement, which is before the time to grant, so before the coordinator signs the grant agreement, we do not yet have the project results available. So we would be trying to regulate something that does not exist yet. Instead, once the results arise, we can have a joint ownership agreement together with the other partners that regulates the results. Another reason is that the consortium agreement involves all the partners of the consortium, and it's true that there can be jointly owned results, but not by, very rarely by all the partners of the consortium. So most likely by 3, 4, 5, or 2 partners. Therefore, we would be involving, if we would put this information into the consortium agreement, partners that actually have nothing to do with the results generated. This is, yes, how the partners can assert the ownership of the project results. I said there's a default rule in the consortium agreement. And then again, once the results are going to be available, they can have a joint ownership agreement together to determine the uses of the results. But also, for example, could be as yes here. Normally, this is what comes inside the joint ownership agreement. So the identification of the joint owners, the allocation of the shares. If they can have a usage that is commercial or non-commercial, that's very interesting. For example, when we have companies, that happens very often, and universities within the consortium. So we can say in the consortium agreement, which becomes also a sort of licensing agreement later on, who and when can use the results in a commercial or non-commercial way. Probably universities are going to be interested to use the results for teaching activities, for example, or for further research activities, which are non-commercial uses of them, whilst companies would like to use them in the market. So this way, we can already foresee a distinction in that. But also regarding the protection, because now we have the results, just a few partners are involved. For example, who's going to pay for a patent that is there, and who's going to be in the patent as a assignee of the patent of the invention itself, which is also a question that is not answered by the grant agreement or the consortium agreement. We have developed actually already a few years ago, I think in 2022 or 21, fact sheet on the joint ownership agreement, and it's available in. Also, this is interesting in Horizon Europe because we have a new list, a new document that needs to be handed over, which is the results ownership list. The results ownership list is a formal communication to the European Commission that the parties have found a potential division of the ownership among themselves. So it's not a real agreement. So it does not necessarily divide the ownership officially between the project partners, but it's important because the European Commission requests to be communicated this list before the final payment is issued. So that's something quite relevant, because theoretically, without this list, the final payment cannot be issued. And so it's important at least to think about it. And if you have had already a joint ownership agreement discussion before, then it's going to be much easier to fill in this list at the end of the project activities. And then we have the point of access rights, because we need to remember that into a project, ownership is not everything. In fact, even if I'm not an owner of the project results, the grant agreement and consortium agreement anyway foresee that I will have access to the project results or background whenever those information are needed in order to either carry out project activities or carry out exploitation activities. And it's very important because people tend to forget and not to read the agreements of the project. The standard DESCA model says that parties have access rights to results and to background for the whole duration of a project and up to 1 year after the project is over. So it's quite an amount of time because normally it's 3 or 5 years for the project plus 1. The point is, however, that 1 year can be changed. So I found consortium agreement that had throughout the whole duration of the project, plus 5 years after the project is over, even one at 10 years after the project is over, which means that you are granting access to your background and the results that you have generated for 15 years. And if you sign the consortium agreement without really reading that, you are compromising to something that's quite unacceptable in many cases. Because 1 year, okay, that can be bearable, but like 5 years already becomes a little bit too much. And so please always what's written down in the consortium agreement, or at least send it to the helpline. It's going to read it for you, at least this part, and it's going to provide you with an answer as well. So basically, what the grant and consortium agreement do is to provide access, can say also a license, to the background and the project results to the project partners that need those information in order to carry out project implementation activities. And in this case, the access is completely free, royalty free. Or in case the access is needed for exploitation of results, it is provided on fair and reasonable condition. And here, with fair and reasonable condition, we basically open up a Pandora's box because nobody really knows what it means. And there's no way to actually know it in a general term because it's specific to each and every project. So we try to describe it as a sort of attempt of calculation based on the characteristics of the results, the use that is done of the results, the economical advantage that results provide to its user, the economical advantage that is provided by inserting those results into a production chain and see what's the improvement and then calculate a royalty based on that, or on previous contract that the company had already done in the market for technologies that are similar to the ones that we have. There's many ways to do that, and no one is better than the other. It's just relative to the characteristics of the project that we have. So this is something really complicated, I would say, that needs to be discussed within the project, and that should find its place potentially in a joint ownership agreement in case you have the chance to discuss about it. And then, so after the ownership and after the access rights, we come to the point of a general obligation to protect, which I suppose it's something that you were all waiting for, given also the title of today's presentation. General obligation to protect is a rule that proceeds from Article 16 of the grant agreement and then is adopted in Article 8 of the consortium agreement. And basically, the general obligation to protect foreseen that participants must examine the possibility of protecting the project results and should or shall protect them as any time in which the protection is possible and the protection is justified. Now, what does possible and justified means? Also here we have, let's say, knowledge hole, in the sense that there is no clear explanation, let's say, of this really. But we can, I can provide you one right now, in the sense that we protect whenever this is possible. And the idea is that protecting result is not always possible because not all the intellectual property rights fit into the intellectual property generated. So also here, it's important to understand the difference between IP and IPR. Because, for example, an idea by itself, it's something that we cannot protect through intellectual property rights. And so saying that I'm going to protect the ideas generated by the project is quite a big mistake, because ideas, protection applicable on ideas is not possible. And here, I think here, yes, you see what kind of intellectual property rights are applicable to different intellectual property creations. So patents for inventions, trademarks for distinctive signs, industrial design for the appearance of the product, copyright for work of arts, and confidentiality, so trade secrets for information that needs to be kept secret. So it's important also to remember this, that intellectual property rights are a juridical construction that has been created specifically for a certain output of intellectual property, and so for a certain type of result. And we cannot generally provide a protection that we can say covers ideas or covers the outputs of the project, because that wouldn't be enough for an evaluator as a definition. We need to try to be as specific as possible, saying that, for example, for package 2 is going to be producing key exploitable result 2, which is an invention. And that invention, as such, is going to be protected by a patent, for example, or that a paper generated into as deliverable 5.2 is going to be protected by a copyright. So every time we talk about protection, we need to be as specific as possible, and many mistakes are made under the impact part of the proposal exactly regarding this, because projects simply say that as soon as the results are going to be generated, intellectual property rights are going to be applied to ensure protection. It doesn't really say anything about that. We need to try and be as specific as possible in order to be more convincing as well for the evaluator. And the second point is the justification, which is a little bit more subtle in the sense that protection is justified when our protection activities are in line with what we have foreseen in the description of action, so that there's no obligation to patent necessarily if we have an invention that could be patented. Of course, if our goal is to commercialize that invention, then we have the obligation, because the protection is justified in the sense that this protection is going to make our life much easier when we're going to be commercializing the invention, because we will have a monopoly and we can decide who's going to have access to that invention or not. And so given the end that we have for our result, then we need to find a way to make that end happening and be as simple as possible, as efficient as possible. And so we need to justify basically the protection through that. But another example, let's say that we want to have or we are generating a software that is actually meant to be published on GitHub, and for everyone to have access to that, everyone able to build upon it, to modify it and make it available once again. And so completely open, completely free for everyone to use. Even if that software could potentially be patentable, let's say, or protectable in other ways by trade secrets and so on, then, however, compared to the goals of our description of action, probably protection for that specific piece of information generated is not justified given the circumstances. And the circumstances are the description of action. I have another example just to try and make it even more clear. We had this project that was the goal was producing pest controls in terms of poison for red ants that were living in the U.S. and in the south of the U.S. and north of Mexico. Those pests were produced in France, and so we were asked whether protection was justified, and the answer is yes, protection is justified, but just in the territories that are involved into the exploitation activities, which are, of course, Mexico, the US, and also France, because it's the country in which the compound is generated. Of course, protecting in Norway, for example, or in Russia would make no sense given the circumstances. Again, these are other circumstances than the example that I've made you before, but it's probably also helping you to understand that there is no general sentence that you can use in a proposal that clarifies the protection strategy, but everything needs to be weighted and needs to be applied to the characteristics of the project itself. That's the main message here, let's say. I think I said it. This slide has come with me from the beginning, but just to give you a visual overview of that as well. Intellectual property and intellectual property rights, those are two different things. I told you already why they different between the other. But if we focus on intellectual property right, I will not mention them all and their characteristics. If you'd like, online, and I will send it to Marius also later on. We have an e-learning page where you can find the webinar that I do on Introduction to Intellectual Property Rights, where I talk about all these IP rights specifically in detail. Here today, for sake of time, of course, I just want to make you an overview of them and tell you that we basically divide them into intellectual property rights that needs to be registered in order to be enforceable, which are trademarks, patent, utility model, industrial designs, and so on. So these you need to go in front of a regional or national authority that is going and file for a IP right request, like for example, a patent application. And they are going to be granting you if the characteristics of the intellectual property rights are met. Patents, for example, there's novelty, inventive step, there's novelty, there's inventive step, there's also industrial applicability. Other kind of rights, for example, the copyright, rises immediately without needing to be registered before or at the moment in which the work of art is created. So let's say that tomorrow you write a book and you finish it, and from that moment on, your book is actually going to be copyright protected. In many cases, you can also register the copyright, but that's just to have the proof of the date in which you have finished your work of art. So you finish your book and you register that before industrial office of your country, for example, and this way you have an official stamp that says that on the 27th of June 2026, you had written this book. In between, we have the so-called soft IP or trade secrets or know-how. This is information that is valuable as long as it is not shared with anybody else. So formally, there is no form of protection on the soft IP that is granted by an authority. However, the protection is given by the fact that the owner is not going to share it and by the technical means that are applied in order not to share it. For example, the Coca-Cola company is kept into a safe, or also the Google algorithm is not shared with anybody outside the Google company, and just a few people actually know the characteristics of that. So it's in between because you don't need to register that, but you also don't share it, and it does not have the characteristics of the registrable or unregistrable intellectual property rights. But instead of, let's say, talking individually about every IP right, because we would stay here until this afternoon at 5 o'clock, I'd like to leave you like three main principles that normally apply to all intellectual property rights that you should be aware of, I think, after this presentation, and that can be helpful for the projects or the proposals. The first of them is the principle of territoriality. This principle says that intellectual property rights are territorial and that they are applied and they can be enforced only in the countries in which you have received a granting or in which you have applied for the granting. So that patents, for example, can be activated or use the word before now. I don't remember that. Patent protection can be activated in the US if you have received a granted patent from the USPTO, the same for France, the same for Italy. So you need to identify the place in which you would like to receive protection. And that's what I was telling you before with the ants example. We want France, the US, and Mexico because France is the place where the compound is created. US and Mexico is where it's going to be used. Russia has nothing to do with that. Also, there are no red ants, and it's too cold for that. So it's necessary to identify a strategy, let's say. The second is the passivity. And this is a very common mistake, unfortunately, especially between researchers, because many came to us and said, like last year or 2 years ago, we concluded our research. Everything went well. We went to the EPO. We filed for our patent. We received a granted patent, and so now we started commercializing our invention. But we received a cease and desist letter, let's say from Siemens, a big company or whatever other big company that there is. How is it possible? There was an authority that told us that our invention was new and that our invention was inventive. And so how is it possible that we are breaching somebody else's rights? That does not make sense. It does make sense instead, because intellectual property rights are passive rights, which means that through them you can prevent others from using your invention, but you don't have a allowance to operate in the market. That's something else. That's called FTO, freedom to operate. And so the point is that I'm going to skip the slide and go directly here. Very often intellectual property rights are used combined for products, and very rarely they are found alone. So let's say that these researchers had found this new system to expel moist, which is the patent that, say, you can see down here. See if I have all. Don't have laser pointer here. You can see the laser pointer, and the patent basically is this one here. They had it, they filed it, they got it granted, and then they have produced a shoe. And this shoe is now on the market. Of course, everyone knows that you cannot use the Nike ribbon. That's fine. But they were not aware of the existence of the patent of this material here, or also the patent on the laces, for example. So what happens that they are actually infringing somebody else's patents, the ones that you see there on the right-hand side, by commercializing this product, which is the shoe, even without the Nike ribbon. Even if they had their initial patent, so this one here applied in the product, because this patent only said that nobody in the market was able to use this moist expulsion system that they had invented, but at the same time, they were not aware of the existence of these other two patents. So that meant that despite their patent filed and granted, they were liable for the breaching of these other two patents. So please don't make this mistake. Also in the proposal saying we will protect our project results through a patent, and with that patent we're going to be able and free to operate in the market. That's a mistake. And finally, the third principle is the duration of the protection of the intellectual property rights. As I said, there's a monopoly. The monopoly is the principle that we saw before, which is the possibility of excluding others from the usage of the results if we want to. But this monopoly is limited, because if it was unlimited, then it would be an unfair advantage for its creator. And so there is a limit of huge limit for 70 years for copyrights after the death of the author. 20 years after the patent application. So, for example, if it takes 2 years to receive your granting on the patent, then you still have 18 years, provided that the fees are paid. In this case, industrial design for 25 years after the registration, and trademarks can be renewed indefinitely. But the point is that if you find, for example, a technology, for example, in our previous example of the shoe, if you find a technology that could be deemed as a risk for your commercialization, for example, you should immediately check where that patent or other intellectual property right is active, because maybe you're going to be operating in Latvia and in the Baltic countries, and that patent has been filed only in China and in the US, and that wouldn't be a problem. Then you would be free to do whatever you'd like. Or also the patent has expired already, either because it's older than 20 years and you're 100% sure that the patent has expired, or because the renewal fees haven't been paid. And then going on there's it's like closing the part on the protection. There's the general obligation to disseminate. So the grant agreement says that project partners are obliged to disseminate the results swiftly, so as swiftly as possible. And this means that we need to make sure that all protection ways have been exhausted before we start the dissemination activity. And this is very important to remember because one of the characteristics, for example, of patent protection is novelty, which means that if we disseminate before, so if we, for example, publish a paper before we try to file for a patent application, then we are 100% sure that our patent is not going to be granted because it's not going to be new anymore, because all the information that we have inserted into our paper are going to be used by the examiner in order to motivate that our patent is not novel. And that's also why in your consortium agreement, here, yes, you're going to find that in section 9, if I'm not wrong, either 8 or 9 probably, there is a dissemination checklist that says that you need to wait a certain amount of days before you can actually disseminate your project results. You need to communicate to the other consortium partner that your intention to disseminate, and once this amount of time has elapsed, then you can potentially disseminate. But you need to be careful and read the agreements again here, because those 45 days are the standards foreseen in the DESCA model. But I've seen consortium agreement having 30 days, even 15 days, which is the minimum amount of time because it's foreseen by the grant agreement. I've seen consortium agreement have 90 days, 120 days. So this is something you need to be aware of, especially if you are a researcher, because if you need to wait 120 days after you have or communicated your intention to disseminate to your other partners, maybe you're not going to be very happy about it. Even 45 days is quite a long time for you, but it's the time that is necessary for the industrial partners of the consortium to check whether the information could be patentable and so protectable in other ways, and then protect them. Because once the patent application has been filed, then you can do whatever you want. You can disseminate or communicate or disclose any kind of information that because in any case, the examiner is not going to be able to use that information that you have disclosed after the date of filing to motivate the lack of novelty or the lack of inventive step, for example. This is very relevant, and everyone needs to be aware of that, and too few projects, unfortunately, are in fact aware of this. And another question mark that we often receive is, how can you tell me that I have the duty to protect, but at the same time, the Commission is telling me that all the information that I provide and all the data and the access need to be free to be accessed. So there is open data and open access. In other words, how can there be a general obligation to protect and a general obligation to disseminate together at the same time? And well, this is a common misconception, unfortunately. I try to explain that by using the example of the patent. Let's say, if you file for a patent, your technology is going to be explained in the patent document. There's going to be an abstract, there's going to be claims. Now, in the moment in which that patent is granted or even applied for, it is going to be published in a public accessibly repository, which is, for example, in Europe, is SpaceNet. And so it's going to be available for everyone. And everyone is able to learn from that document and to understand the invention and the technology that you have generated. So there is open access in this specific case and open data because the information is free floating, is, let's say, communicating freely. The only limitation to that is the fact that you're not able to use it commercially, but that's another thing compared to open access. So don't think that there's some sort of incompatibility between protection and dissemination. In some cases, like patents, they're actually very, very compliant to one another. The point, so the main challenge comes when we are in this in-between field of trade secrets, for example, because in that case, we keep the information secret. And in that case, data and access are going to be limited. And so we need to find a way to explain to the project officer, to the project, why we need to keep some of this information secret and what kind of exception to the open data and open access that is going to be. But that's a very, very limited amount of cases that can happen through the trade secret. And in the 95% of the cases, the project will have free, findable, accessible, interoperable, reusable data and open access papers that have been published. So really don't be confused by this potential hiccup between protection and dissemination activities. Also, we try to explain this with more words, let's say, than just the 5 minutes that I have used. I hope nonetheless that I have used interesting examples that could allow you to better understand all the topics that I tried to share with you. But there's a fact sheet dedicated to that, which is Open Science in Horizon Europe, and you can have a couple of additional information. So finally, with the general obligation to disseminate and general obligation to protect, please note that general obligation to protect has a sort of precedence because if we apply the general obligation to disseminate before, then protection could not be applicable anymore. And so try to comply with the general obligation to protect before you comply with the general obligation to disseminate, because you're always able to comply with the general obligation to disseminate. In some cases, if you already publish, you're not going to be able to comply with the general obligation to protect. Couple of infos on open access as well that are anyway reported in the previous paper or fact sheet that I was showing to you. And also interesting is the fact that all the costs that you use for publications and for protection are reimbursed, are eligible costs. So will be reimbursed as long as you thought about them in the proposal. So as long as you've inserted them in the budget. And a tip here that I've seen in many projects is that partners or the coordinator have a pot for IP protection and a pot for, like in the same pot, let's say, for dissemination activities, for publications. And when they use a little bit more of the one or a little less of the other, they still have it in, let's say, in the same place. And they are more flexible, let's say, in applying protection activities and dissemination activities. Then we get to the last point, but very important because it's actually our goal line of all the dissemination and protection activities, which is the exploitation, because we apply protection so that we have a monopoly and exploitation is easier to be carried out. We apply dissemination because this way third parties that are potential targets are aware of our outputs, of our results, and may be interested to use them and so to exploit them. So this is our final goal, and the Commission says that results must be exploited. And if they're not, then they are going to be published on the Horizon Results platform. In this rule by the Commission, this seems to be a little bit a sort of punishment for us to be on the Horizon Results platform. In reality, I've seen the platform and see how it works. I've seen the people that are working there. And my suggestion would be to anyway put the results in there if possible, because it's a shopping window for the results anyway. And if somebody is interested, then can take the results or can contact you from the Horizon Results platform. So It's really there, it's for free, it's a free dissemination activity that is offered to your project, so why not use it? Don't take it as a punishment, but instead as an opportunity, basically. And yeah, sorry, as you know, there is the PDEC, which is the document that connects all the dots between the dissemination, exploitation, and communication activities. It's this one in here. And it's where you basically have to explain why your exploitation and dissemination activity, protection and dissemination activities are aligned in order to ensure a smooth exploitation of project results. This document is not written in stone and it evolves through the project life cycle. In fact, you normally have one as a deliverable at the beginning of a project, and then month 18 and so on, it's going to be reproposed as a new version to communicate also to the European Commission what are the changes applied and how the project is evolving in terms of these very important activities that we're trying to describe now in this webinar. So, common misconception that I've introduced already before. Sorry, let me just jump here and then I'll go back. Very often project results consider exploitation as monetization. That's a mistake. In fact, there can be, of course, the cases in which you have the next unicorn. But very often, especially in RIA or IA projects, we are going to be having results that still have a low technology readiness level. And so they're going to be used for further research. They are going to be used also for educational activities. They are going to be used for policy reports, government reports, and so on and so forth. These are absolutely also allow the free use. That's also absolutely an acceptable exploitation method. We just need to put it in context with what we had written down in the description of action. And of course, if our description of action said that we would be creating the next unicorn, then we need to find the appropriate exploitation method, which probably is not to allow free access to the project results. It's just say just like a suggestion or like that. Nothing serious. Nonetheless, the exploitation strategy, as I said, needs to be in line with what was written in the DOA. And so if we want to set up an exploitation strategy, and that is going to be, let's say, the most important part of the plan for dissemination, exploitation, and communication of project results, because it's, as I told you, it's the goal of the protection and dissemination activities, we need to have the purpose of the project results, the ways in which they might be exploited, so not necessarily commercially exploited, the measures in terms of intellectual property rights that are going to be applied, and if there is going to be some non-commercial or commercial ways of protection, and also the potential expected impact that they're going to be generating. So the impact is the quantification of the benefits that the usage of the results is going to be providing in a specific field. It can be a social or economical field. It depends. And to do that, we need also to understand the landscape and try to foresee potential problems that could be in the way, like regulation, other intellectual property rights. Please remember the example of the shoe. If you say that you're going to be commercializing, you need to try and tell, like, the supporters that there is not going to be any form of issue in terms of other IP rights, or if there is going to be, which is acceptable, and also it's a plus because it shows that you were searching for it. You need to explain how you're going to come around that problem, for example, through licenses. And then each and every project has different characteristics and different potential problems coming up, like regulations that can be societal or and environmental ethics topics, or also standards. Very often standards are an issue because in order to be able to commercialize, let's say, you need to comply with certain standards. All these are part of the necessary pieces of the mosaic in order to, first of all, carry out or let's say draft a effective proposal, but then again to efficiently say explore the exploitation methods that can be applied to our specific project, and so create the plans for dissemination exploitation of project results and adapt it and then apply that to reality. Also, one new thing that the Commission has brought out is the tracking of research results, which means that the Commission can approach you up to 4 years after the project is over and ask you to provide some, let's say, documentation or examples of the usage of the result that has been done. This approach is simply, let's say, informative because it's a lot of money that is used for Horizon Europe, and they would like to show some sort of interesting output generated, and so this is the tracking of the research results project. So it's not like police coming after you before for not using properly the project results. Absolutely not like that, but it's just to find meaningful examples and say victory cases or yeah, powerful examples also of how the money has been used in order to generate results with high impact. Also, my personal sympathy for the Horizon Results platform is always there, and I like going there and see what's actually available, which is going to change name. Actually, I shouldn't use this name anymore. My colleagues from there told me that. So yeah, please also ignore this. If they would know it, they wouldn't be so happy. I'm not still sure what's going to be the new name because we're doing a lot of modifications there. But let's stay tuned because it's going to be coming. And as I told you, I'm very much happy and open for questions. So if there are some, very happy to leave the last 10 minutes of today's presentation to them. Yes, sure, Maris, please.
Thank you very much, Michelle, for the excellent presentation. It's a first of all. And of course, about the questions for the audience, you can raise a hand and ask a question directly or write in the chat. And for the beginning, I will ask the first question to you,
Yeah, sure.
Michelle. So usually in Horizon Europe projects, they are participating several partners or 10 or 15 partners. Maybe you can tell the best practice how to deal with the IP rights and results when in the partnership this developed is jointly in several consortium partners. How usually they do that? Is it like proportionally? Is it like related to the task or work package? How do they deal with this? Of course, I know that they write in consortium agreement about the IP rights which were owned before the project, and what happens during the project life cycle and after that. How the other partners deal with this situation.
Yes, I think I've explained it a little bit with the rules for ownership that we saw before, and theoretically, the Commission thought that this would be a problem that is going to be solved through the results ownership list, because in there parties should determine also the share of ownership that they're going to be having of the project results, but yeah, it's not like an official agreement. So still the problem that you say is still there. I told you that there are, let's say, objective ways to try and determine the contribution to the project results that every partner has done. So for example, the background, for example, the person per month used in order to generate the results, the machinery and everything. However, what matters the most finally is the will of the project partners. And also in many cases, is the will that they have to undergo costs after the project is over, because very often results need to be upkept after the project is going to be over, and the upkeeping is done by their owners. So being the owner of the project results not necessarily and not always means to be actually in a advantage position, but probably for the years after the project when there is no funding anymore, well, maybe this is just going to be a cost for you. And so you need to take this into consideration as well. So I've seen examples of partners that theoretically would have rights, would be also potentially be considered joint owners, but finally stepped back because they didn't want really to have the costs of the maintenance after the project was over, and they didn't really think that the results that they had generated had a commercial value, and so they left them to other partners that that were more interested in that. So many potential objective points of view, yes, but finally what matters is the will of the project partners. And additionally to that, also another thing, if we bring in the intellectual property rights, which again are something different than the results themselves, you can have a situation in which results owner are the owner of the results, but for example, there is an exploitation partner within the project lifecycle that has filed a patent on the results, and of course, in agreement to the other owners, he is the only one on the patent by himself, which means that the IP belongs to a group of partners, for example, and the IPR is belonging to another group of partners or to a single partner. So it's not necessarily said that the owners are automatically, the owners of the IP are also automatically the owners of the IPR. This again is undergoes the will of the different parties who can do whatever they would like, depending on what they think is going to be more advantages for themselves, for them. And so this can be written down in the grant agreement. This can be written down in the joint ownership agreement. But I would say that the most important places to talk about this are the project meetings. And very often we try to suggest to leave a section of the project meeting for exploitation meetings. Not that much also, it could be half an hour, it could be 40 minutes with only the partners that are involved in the exploitation, for example, or in the ownership of the results, and not leave it only in the last month of the project when you will have to do this document the results ownership list, but maybe start also from the very beginning. You're going to have very short meetings because there are no results yet, but still you can try to talk about what is it that the different parties would like to do with their results, because that's what really matters finally the most. That's my view about that. Sorry, talking too much today. And I don't see raised hands, so I see the chat. Wait a second. I know it was you writing mine.
It was
Yes.
me, like
But
more.
yeah, just for your information, in case, for example, you come up with a chat right with a question right with a question right after we're over, you can anyway refer to our helpline, which you can see here, or also to our training account, which I think I have up here before. With the training account, yes, here I will be answering you directly, because it's basically just me managing it at the moment. Or also you can write to the helpline. What there's a question by Carlis. What is the most common mistake you've seen in project proposals in relation to IP or the exploitation part? I think I said it before here when I was talking about the different kind of intellectual property rights. I think regarding protection, the most common mistake is to have the standard sentence that says results are going to be protected once they're going to be generated. We will apply intellectual property rights. Well, like you need to be lucky there if you find an evaluator that knows nothing about IP rights, then he's going to take it for good. But the other two probably not. You should have a 3 out of 3, so it's not going to be that easy. I wouldn't like it as an evaluator, of course, because if you have the chance, you need to be precise. You can take also a paragraph to describe that, but at least tell us what is the form of IPR applied to which kind of IP, as I was telling you before. The CAR2 is going to be like a compound to treat headaches. So what are we going to be applying on that compound for treating headaches? Is going to be a patent, because a compound is protectable through a patent. We believe that the compound is new, it's inventive, and it's industrially applicable. Therefore, we're going to be applying many information more instead of that really awful sentence that I've seen in so many projects that I really don't like that much. And this is regarding the protection. Regarding the exploitation is regarding the exploitation, it's a little bit more complicated because we need to try to understand what's the use of the results before the results exist. But again, here my suggestion would be try to be also as exhaustive as possible by providing, for example, like examples of the fact that you've been researching also for competitors in the field and for, say, a potential market pool connected to your market push in the way you're going to be using the results, so that the final output of the exploitation is convincing. And I haven't talked about this a lot, but you really need to try to connect to your user of the results an impact. So what you foresee that is going to be happening in the social economical tissue in the future after the results have been generated and used in terms of quantifiable benefits generated by the results, which AKA is the impact. Were there are cases, even though there were taken measures, still there was an infringement. Yes, the good thing is that you can take measures after as well, because I gave you the example of the shoe before of the colleague surprised by the fact that they had received a cease and desist letter. At this point, we still have the chance to make it right, to fix it. Because you see the cease and desist letter, you say, okay, we made a mistake. I'm sorry, we were not aware of that, but we would like to keep on commercializing our product. We would like then to have a license for this patent and for that patent. So we're going to pay something. Probably in that case, it was a royalty, for example. And the company said, okay, you're going to give us a 5% of the sale that you're going to be doing, and then we're going to be fine, and you can continue doing that. So the fix is the licensing in this specific case, and you can make it good. You can make it good as well. So this is an example of a case in which, even though there were taken measures, or at least the researcher thought that they had taken measures because they had a patent, but they had gotten that wrong. Nevertheless, it was their mistake, but they could fix it by licensing in those technologies that were needed or that were supposedly infringed by the others. That can be a problem in the sense that very few have the chance of really stand in court for an IP trial. And so in many cases, even if it's not really 100% the case that the patent is clearly an infringement, this kind of arrangement are preferable in a way than the ones that would bring you into court. As you know, we need to try and avoid as much as possible the trial as small and medium enterprises or as researchers, because it's not a very smart thing to do, and a lot of money would then get lost. Gone relation between IP and commercialization of result. Should one be emphasized more over the other? And yes, I would say yes. I would say that commercialization of results should be emphasized. And there is an easy reason for that, because intellectual property protection is aimed at ensure or making easier the commercialization of the project results. We need to consider intellectual property right protection per se as a cost. And this cost, like in every company, if we have a cost, that cost needs to be aimed at a benefit, because otherwise we simply have a passive in our balance, and it's not good, of course. So, however, if that passive is aimed at getting some sort of advantages, then it becomes an investment. And therefore, if we aim at the commercialization of the project's results, we consider the protection a cost that, however, puts us in a better position in order to commercialize the results, and therefore it's an investment, because it's going to bring back money, basically, later on in their use. And so please also take that into consideration if you're writing proposal, or if you're inside projects, that alone intellectual property rights are just costs and should be avoided. But if inserted into an exploitation strategy that is um, credible and effective, then it becomes an investment. And that's what we want to have in our project: investments, of course, and not just costs. So the classic professor's patents that are filed in order to be fed to CBs and sit into a drawer are something that we really wouldn't want to see anymore, because those are simple costs that never become an investment. Very important. Oh, okay. There's another question. What are the most common IP-related mistakes made by consortium partner in Horizon Europe project, and how they can be prevented? Well, I said it. The most common is the early publication, and it happens especially in consortia that are mixing universities and companies, so that happens often. Unfortunately, partners do not read the project documentation. Partner B is publishing heavily everything that he or she has, because that's his job. He's researchers inside a university, but he or she does it before the given time that I was showing you before. I think I have the slide down here, if I'm not wrong. Here. So there were in the consortium agreement 45 days written before, but they have they haven't been seen, and so there was no communication. The publication comes out and completely destroys every potential protection method that was applicable, which is a huge blow to the project, because then exploitation is going to become harder, because there is not that monopoly anymore on which we could have counted. And I have an example of this, which was a very interesting project for treatments on the cancer of metastatic cancer. That was a really interesting technology and so on. But the project had published everything on, like, all the whole system on its very website. So a communication activity actually in this case was destroying all the potential for novelty and patentability. Unfortunately, I got there a little bit too late, and everything was already available online, and so there was no chance for patentability anymore, which meant that very few pharma companies would have been then interested in adopting the production of the results because of the lack of intellectual property rights. Then, of course, the situation can be potentially rectified in the future because this kind of research are still in very embryonal and initial phases. And so having learned the fact that this is a danger can help for future development of the drug, let's say, that is going to be protected, the development itself on a free access technology, which is the one that is going to be created now. But still, it's a pity because also it's not like you have to pull out the money of your pocket directly. The costs for protection of patents are um, are eligible costs, so it's going to be anyway something that is foreseen the project within the project life cycle. This is the king, I would say, of mistakes. Then there are other more little diversified mistakes. For example, choosing option 2 in the attachment 1 of the consortium agreement while listing the background when you should choose option 1. That basically option 2 says that no information is going to be needed by the other project partners in order to carry out the project activities, even if, for example, you are a very important university within the consortium that definitely is going to share information. That's a mistake on 2 levels. The first one, because you're not communicating what information you're sharing, and so you potentially are creating problems for the other partners throughout the life cycle of the project. And secondly, because you're by not telling what information you're sharing, you're also not providing any objective proof of a contribution into the generation of a project results. So you're basically making a damage to yourself as well. Other, let's say, other potential. I could go on, Marius, Marius also with this kind of mistake for the whole day. I will make just one last additional example, which was regarding open access that I was telling you before. Partners think that openness means not protectable, and so they completely forget to think about any form of protection, thinking that the Commission wants it to be so. That's not the case. Open data and protection activities are go hand to hand in the project, and you need to be careful, let's say, with that. These are 3 examples. And yeah, these were 3 examples. And one last question: how do you see IP ownership and protection evolving in the era of AI-assisted research and innovation? Were there any cases of AI things? Can you shortly share it? Yeah, so we have a dedicated webinar on artificial intelligence with a patent attorney that on a day-to-day basis works with AI. The trend at the moment is that if an invention has been generated by a AI like robot or program, this invention does not belong to the AI itself, but to its to the creator of the AI, because the AI does not have any form of juridical capability, and therefore there cannot be the owner. There have been sentences regarding that in decision regarding that in Germany, in the UK. The only positive or let's say the only decision that was giving ownership of the creation to the AI that was issued was by a court in South Africa, which doesn't really have a lot to do with us. But otherwise, the outputs and regarding the ownership of judges across the European Union, but also on the other side of the Atlantic, is that the ownership is identified with the creator of the AI, of course, but not the AI itself. But of course, it needs to be like a novel invention and so on. So we need also to check all the other requirements that are needed. And I think with that, Maris, we've exhausted the question. It's been a pleasure for me to be with you. I'm going to send you the slides right away, and also our e-learning page, so that if somebody wants to cover, for example, the webinar on AI is actually there on that page, so everyone is free to watch it. It's from Robert Harrison. There are two of them, IP in artificial intelligence and IP in artificial intelligence advanced. Very interesting webinars. And one of them is coming, the webinar on EU AI Act is going to be on the 7th of July, which is going to be our last webinar, of the semester, that going to be coming back in September.
Okay, thank you very much, Michelle.
Thanks to
This
you.
link, if you could share with us, it would be very, very good.
I
Of
will
course, the
give you a
summer for
follow-up
us
email.
is coming as well, you see right now. So
Yeah.
people are less right now, but the summer in July and August, it's the high season for us and for the others. So hopefully they will also manage to see this. And thank you, Michelle, once again for your insights today. It was very good knowledge for us, for you, and we appreciate your time. And thank you
Thank
all
you.
for the other participants as well from the webinar. The materials we will send after today, after the seminar. And I wish you all the great summer, uh, great weather, hot weather, and then, uh, to see you in the next seminars in RTO or EOT Plus or IP Helpdesk as well. Thank you very
Thank you
much
very
and
much.
have a good day for everybody.
Bye bye.
Bye.